Well, in this video, I'm going to talk to you about grandparents' rights in family court. Now, what happens with me? Oh, forgive the hat, by the way. I'm going through a bit of a sulky. So, what happens to me when things don't go the way I would like them to go, and I feel like a big miscarriage of justice has happened? But there's nothing I can do, nothing you can do apart from learn from it, and grow from it, and get stronger off the back of it. So, I have a 24 hours of just numbness and letting it settle in, which is what I'm going through now. And it's not even my grandchild. So I start talking about it and I start trying to raise awareness of it and see what happens. That's what I could do. And that's how I roll. And that's how I cope with things. Yeah. So, this is just my opinion. It's not law. It's not anything. It's purely my opinion. Grandparents, in my view, often face significant challenges in family court when trying to maintain relationships with their grandchildren. And the system does seem to treat them with contempt, or at the very least, unnecessarily difficult. The reason for this is deeply rooted in legal, societal, and psychological biases. And here is why, in my opinion. Grandparents have no automatic legal rights, unlike parents. Grandparents do not have automatic parental responsibility or direct rights to see their grandchildren. This means they have to ask permission, so you get a C2 form before even applying to court with a C100. An extra legal hurdle already right from the outset that immediately puts them at a disadvantage. The court prioritises parents over grandparents. This is a fact. It is not fact that they treat dads any differently. It just weighs heavy on that side of the fence. The legal system is heavily biased against towards parental autonomy, meaning that the court assumes parents know what's best for their children. Even when a parent is being unreasonable by blocking contact, the court is reluctant to interfere unless harm to the children can be clearly proven. The objections from the parents now carry more weight. If a parent objects to a grandparent contact, then the court is likely to side with them unless the grandparent can prove that the cutting off the contact is detrimental to the child's well-being. Many cases involve parental alienation, where one parent manipulates the child into rejecting their grandparents, making it even harder. There's a high legal costs and emotional costs involved. The process is expensive, slow, and emotionally draining. Grandparents often don't qualify for legal aid unless there are special circumstances. Mediation is mandatory, even when it's clear that the parent will refuse. So from the outset, the outsider mentality in court. So basically, the family court often views grandparents as an extended family rather than essential figures in a child's life. This is outdated and ignores the fact that many grandparents play a crucial role in raising their grandchildren, especially when parents separate or one parent is unfit. If social services are involved, it's even worse. So if children are in care, grandparents are often overlooked as potential carers. Social workers sometimes assume that older relatives are unsuitable or lack the resources to provide full-time cover. Even if an alternative is foster care with strangers, that doesn't make sense. What needs to change? So grandparents need their rights and recognition needs to be put in place. The law should automatically recognise the importance of grandparents and remove the need for a separate permission application. There needs to be less bureaucracy, more fairness. Courts should presume that grandparents have a positive role unless proven otherwise, instead forcing them to jump through legal hoops. Alienation accountability. Parents who block contact without a valid reason should face consequences, just as they would in cases of parental alienation. So what can we do about it if you're grandparents? What can you do about it? So document everything. Keep records or attempts of maintaining contact and messages, and even evidence the meaningful relationship with the child. That be strategic in court. Present a strong case on why contact would be in the best interest of the child, rather than focusing on the unfairness of the grandparent. Get some support. There's legal coaching, like what I do. I think it can help you navigate the system without the unnecessary costs. What happens next? So if the courts grant permission, you will file a C100 application using the same argument that you put informally requested on the child arrangements order. Gather your evidence to support your case, photos, messages, witness statements, and then be prepared to address the child's welfare in Section 1 of the Children Act 1989 in court. And that is how it rolls. If you're a grandparent not seeing your children, I really feel for you, because in today's world, you are, I think with parents working, in many cases, you probably spend more time with the grandchildren than what the actual parents do. And when you go through family breakup and that happens, it impacts everyone, the extended family, the lot. So stay strong, and no doubt we'll speak again soon. Chin up, keep going. Can't be beat, won't be beat.